What if I told you that it costs $20,000 to get this wrong? And what if I told you that you are actually getting it wrong right now? Well, don't believe me? Hours of work is something that we all know should be in the employment agreement. But did you know that normally we have minimum guaranteed hours, but what you actually should have is a minimum and a maximum number? If you're surprised, then I was too, because this is a rule that nobody talks about and everyone seems to be getting wrong. So if you're curious on how you can make sure that your workplace is compliant, then stick around because today's episode is all about hours of work. Hi everyone, welcome back to Lawlands. My name is Sanam and thank you so much for tuning in today. We are going in deep into an area that everyone seems to be getting wrong. And I say that because it's very rare that I am flawed in employment law where something comes up that I just have never seen before. But when I went to go research for this episode, thinking hours of work, I normally know what that means. New Zealand doesn't have a part-time and a full-time. It's anything and everything in between. They do permanent employment, and we know that generally minimum guaranteed hours is the standard minimum. So there isn't anything too crazy that we need to have a look at. But I was surprised to see that the Employment NZ website was very adamant about the fact that hours of work need to be fixed at 40 and the employee needs to agree if it goes beyond that 40 hours a week. And I was just thinking, what is going on? Where does it actually say in the Employment Relations Act or any piece of legislation that hours of work needs to be at a fixed amount and that it needs to be 40, and if it's less than 40 then it needs to be over 5 days a week? I was actually really surprised by this. I went down into the rabbit hole and it took me into the dark abyss of the internet, but don't worry, I have come out of it here to give you the details that you need to know to make sure that you're compliant so that you're not making any of these mistakes. And the first thing that I saw was around hours of work and whether this needs to be in the employment agreement. So we know that it should be in the employment agreement, and I thought that would be the easiest and most palatable place to start. But before we get into it, I just wanted to say thank you so much to everyone for following the podcast and for tuning in week after week. I really appreciate all of the support, and if you don't want to miss out on any of these key insights, then you absolutely need to give Lawlands a follow and jump over onto LinkedIn. The first thing that we're going to look at is what are hours of work. So Section 65 of the Employment Relations Act specifies that hours need to be mentioned in the employment agreement. What it says in this particular section is that every employment agreement, so an individual employment agreement, it must include any agreed hours of work, and it needs to be specified in accordance with Section 67C, and I'll get into what that section means. If there isn't hours of work that's been guaranteed, then there has to be some sort of indication around the arrangements relating to when the employee is required to work or on what days. So normally we would see in a contract, if everything is done up to standard, that there would be, for example, 40 hours minimum guaranteed hours. And then you might also have in there that the work would need to be done between Monday to Friday during business hours between 8:30 to 5:30, for example. Or if you're a hospitality business or a retail business, between those set hours that you have there. So it can depend and it can vary from business to business, but generally that's the kind of wording that you're looking for in the agreement. Then when we look at the agreed hours of work needing to be in accordance with Section 67C, what we see under there is that hours of work need to be agreed by the employer and the employee. And the way that's done is to put it in the employment agreement and for both parties to sign. And when we look at what are hours of work, or what does that actually mean, the Act clearly lays out that hours of work can mean the guaranteed number of hours that you are going to be given. It can mean the days in which you're going to work. And it can even go so far as to mention the start and finish times of work, as well as flexibility relating to certain days and start times and finish times. All of that together collectively can be hours of work. So it can be all of the following, or it could be any component of that. And that's what really formulates and makes up the foundation of hours of work. And the reason why the Act is set out that way is because there are many things that contribute towards your hours of work. You could have maybe certain rostered days that you would work, or maybe you just have specific 5 days a week. It can vary from situation to situation. Now, where I was completely thrown, like I said, was when I looked on the Employment NZ website, and I've got that linked in the description. But when I looked on the website, I was absolutely shocked to see this 40-hour cap. And to be honest, I was asked this question a couple of months ago. But the way that I have always taken this situation is that if your employee agrees to work a set number of hours, then they can absolutely work 50 hours a week or 60 hours a week. It just has to be agreed in the employment agreement. But there is this section of the Minimum Wage Act, which is a 1983 piece of legislation, which details how the hours of work should be treated depending on how the employee works. So what I'm talking about is Section 11B of the Minimum Wage Act, and it mentions 40 hours of work and 5 days a week. And what this section actually means is that by default, employment agreements should not set hours that are more than 40 hours. This is all excluding overtime. So if you're looking at it at a maximum, employment agreements should not have more than 40 hours within a week. If the employer and employee actually agree, then the Act does say, and this particular section does say, that the employee can work more than 40 hours, but that needs to be clearly detailed in the agreement. And if the maximum number of weekly hours is 40 or less, so under 40, we're looking at maybe 35 or a number like that, then the employee and the employer should try. And that's very important. It's not a must, even though there is some information out there that's making it seem like it is a must. It has to be done, but they should try to arrange a working schedule where it's spread over a set period of time, where it's over more than 5 days in a week. So it's all about making sure that you spread out that time. So for example, it would look like 35 hours over 5 days maybe, instead of that 7 days. Now, we look at this and we go, okay, but that's all good, Sana. My agreement has in there 40 hours a week. Sometimes the employee does 45, but we have minimum guaranteed hours. So why is this so important? Because it seems like we've been doing this completely wrong. And I know that there will be some people listening out there that will say, look, this doesn't really matter. It's not something that's being brought to anyone's attention. But I would say, heed my warning. Absolutely be warned, because there is definitely information out there and cases that we can physically see that shows where employers have gotten this wrong and they've been penalized for that. So it is really serious. And why this is so important is that contracts legally need to have an upper limit. So if the employee generally does more hours, then it is good to have a maximum or an upper limit in the contract. And you may be wondering, why would this be the case? Well, firstly, we've got the legislation in place. But secondly, cases like, I'll talk about a few, but Pick Hawke's Bay was a company that went through a personal grievance in 2021 at the Employment Relations Authority. There were a few things that came out of that case. And the first one was that the basis for the applicant's claim, for these employees' claim, is that from time to time, they worked more than 40 hours in the week. And this was evidenced by their wage and time records, not necessarily by their employment agreements. What was found in that case, for example, was that there was a breach of Section 11B of the Minimum Wage Act, because there were two employment agreements that did not fix the contracts at 40 hours. And if they did work maximum hours above the 40, then these were not detailed in the contract themselves. And we know that this wasn't from the evidence that was provided. What that is suggesting is that there's no agreement from the employee that the hours of work will exceed a set number. So it is ambiguous, and because of that, the applicant in that case was successful to bring their case forward. Now, same thing goes in a 2020 case with H4M Corporation Limited. This was a bit of a scary case case, to be honest, because what happened was the employee complained to a labor inspectorate. And I've been seeing a lot of this online, to be honest, as well. On Reddit, I was on a subreddit recently, and everybody was saying, hey, you should report them to the labor inspectorate, let them deal with it from there. Don't worry, the employer will get what they deserve. And it is alarming to see that kind of language. So that's why I say it's really important to be careful. One, because you might get a random labor inspectorate audit, but also two, because the employee might tip a labor inspectorate off. And in February 2018, this actually happened, where the employee said to the labor inspectorate that this is a problem. I have not been paid my sick leave or annual leave entitlements. And because of that, the employee's advocate settled their claim and did everything on the side, but the file was closed and no further investigation was done, right? But what ended up happening was that the labor inspectorate then went in and did a proper investigation and opened up all of the books and found that the records did not actually show the exact hours that these employees worked. And they found that there were breaches there, and each breach was $20,000. So if you breach this particular section of the legislation, then it is a $20,000 penalty. And again, it was the same thing as what I had discussed in the Pick Hawke's Bay case, where the contracts failed to fix at not more than 40 hours maximum per week. So these employees were in this interesting situation where the contract did say that the minimum hours were 32 and the maximum were 40, but the employees were actually working beyond that. And it was a question of, is it overtime? Is it not? So where I would say is the perfect middle ground, or I guess the best place to be, is what we see in Abhishek Quality Foods. And that was a case that came out in 2014. And what was discussed here was basically the semantics of the wording, down to the nitty-gritty, really understanding all of the basics and the basis behind the wording. And it was all about making sure that the contract very clearly stipulated the guaranteed minimum hours and also the maximum upper limit that the employee would be working. Now, I know many of you out there would be under this impression that if the employment agreement says a minimum of 35 hours, then you can give the employee as many hours above that, but you might have to look at the average. But what this is actually saying, and what this section of the legislation is saying, is that you need to have a minimum number and you need to have an upper limit as well. And in this case, even though it took semantics and a bit of back and forth to get to it, the guaranteed at least 35 hours to 42 hours per week was considered as adequate wording. But it still took a whole entire case to get down to the bottom of it. And that's where I would suggest it's really important to make sure that you have the wording right. Even if it's adding in a few extra words in there and really making that section robust to make sure that it's very clear that these are the guaranteed minimum and at a maximum, these are the hours that you would get. So this is a clear indicator of what that wording needs to be. It needs to show both the minimum limit and the maximum limit, and using that kind of wording will be very clear rather than using at least or to, because that can be misinterpreted or it can be ambiguous, and that's what the authority said in these cases as well. This begs the question of how negatively this would actually impact employees. And from the cases that I've seen, I can see that this is more of a concern when it comes to salaried workers. When you have a waged worker, they generally work their hours. In the agreement, you'll have some sort of information around overtime, and that information will be specific to if they tick over their hours, then overtime might be paid at the normal rate of pay. But when it comes to salaried workers, we're very used to seeing reasonable additional hours. So I wanted to talk about reasonable additional hours in the perspective of salaried workers, and where an agreement states reasonable additional hours, is that actually okay in this context? So what we normally see is that these agreements are paired together. They'll have that wording where the hours of work that might be a little bit well remunerated because of the type of salary the employee is on. Generally, salary attracts a higher average wage that you would get for an hourly rate, so that's why it's considered as acceptable. But there are certain circumstances where we've seen these cases being an issue, and it's important that the employer doesn't do anything where the employee works such an unreasonable amount, and instead of overtime, they are just effectively working for free. So you want to make sure that you're not bringing them below the minimum wage threshold. You want to make sure that it is reasonable and additional, maybe an hour here or a couple of hours there, but nothing crazy where they're constantly doing 5 or 6 hours every single day. There is no exact hard or fast rule. It's a fine line. So it's really important to make sure that you are balancing that really well. And the only advice that I could give you as a HR professional, as an employer, is to make sure that you are monitoring how much they're doing. If your workplace is all about flexibility and that they are able to maybe spend an extra hour doing work, but then they get to come in a bit later the next day, then that's a different story. But we start getting into gray territory when the employee consistently starts doing more and more work. And the last thing I wanted to touch on, and it's just going to be really brief, is about 0-hour contracts. I wanted to touch on this before I get into my top tips, and that's because in 2016 we saw that the law had changed around 0-hour contracts. And basically 0-hour contracts were absolutely acceptable and were allowed in the past, and now as of 2016, it's been a while, I know, but just a reminder is that you can't have a contract with no hours in there and ask the employee to be made available 24/7. We can't do that anymore. I won't dedicate this episode to availability provisions, but that is where you would need to cover all of that off. And if you are interested, I'm more than happy to do an episode on that, but I am mindful that it only applies to certain industries and certain people. So I'll get into the last area that I just wanted to cover, which is my top tips. So my top tips are that firstly, you need to make sure that you have exactly agreed on the hours that the person is going to be doing. If you believe that they are going to be doing varying hours, then have a minimum and have a maximum in the contract. You need to have a maximum anyways if the employee is going to be doing more than 40 hours a week. And that doesn't mean that you have to pay the maximum. It means that you'll at least need to pay the minimum, but they should expect that their hours of work may reach that particular amount. And so another tip would be that you can also have it that they may be required to work set hours, and that would vary depending on the time of the year. For example, if it was the beginning of the year and work is generally quite slow, then maybe they wouldn't be doing as many hours as what you factored in for the middle of the year. So it's always important to make sure the hours are reflecting truly or as close to what this employee will be doing. And keep in mind as well that if it's less than 40 hours, then try to spread it over that 5 days of the week. But again, it seems like the way that the legislation reads is that it can be up to the employee and employer, but they need to try to make best endeavors to make sure that it's over that 5 days. It can depend on what the employee may want as well. And maybe they wouldn't want to do it over 5 days. Maybe they want to do it over 6. I've also noticed that many employers will have minimum hours in the contract and then they chop and change the hours. And my next tip here would be that if you require an increase in hours or your employees need to maybe decrease their hours, that can't just be done by you varying hours on the spot. It can't be a unilateral change, a unilateral variation. It needs to be a change that comes from both parties, even though one may be suggesting it, but both parties have to agree to it. And that is the most critical thing. And I can see a lot of employers chopping and changing hours. They decrease hours, they increase hours, but it is really important that you very clearly stipulate what hours the employee will be on. If they're working more, that they agree to working more, and that your contracts cover that off. And if you are bringing them down to do less, then you do need to go down the correct avenues for that. And that could be a letter of variation, or it might need to be a restructure. But like I said, try to tailor your agreements in a way where if you can see that there's trends in business where maybe there's an uptake, maybe that there's a downturn, that you factor all of those in. And I'll link the variation episode that I did as well, which talks all about letters of variation so that you also understand when to use that letter and when not to use it. So you want to make sure that you're not over promising hours. So you're not giving hours that are crazy high and that it's something that's unrealistic or that you're not able to provide as a minimum, for example. I would see a lot of employers saying, oh, this person might end up working actually 45 hours, so I think I'll give them a minimum of that. And then I said, okay, when the hours decrease, because let's say that you're going through a bit of a downturn in business, then what happens there? Does that mean that you're going to now cut their hours even though they're expecting in the agreement to get 45? That just won't work. So this is where the minimum and the upper limit is beneficial, but my warning and top tip is make it reasonable. It cannot be something that is so far-fetched or so far apart that it's unreasonable. And lastly, I would say just make sure that you are tailoring these hours of work to your business. We are moving in a very, very different time. And for all of my small employers out there, I completely get it. A lot of you out there are not part of the gig economy. You're not a part of remote and flexi working. It's very different for you. And if that's the case, then you need to make sure that the hours are very specific to what you require out of that role for your business. The fact that some employees might need to clock off a bit early, some of them might need to stay back a bit late, it's really important to cover all of that off. Thank you so much once again, everyone, for listening to this podcast and for following. I really appreciate the support and I really appreciate all of the interest. I am thinking about rolling out a newsletter, so if you haven't subscribed to the Law Lens mailer, then absolutely do, because I am going to be bottling up all of my posts, all of the information, all of those little tips and tricks that you might need here and there along your employment journey. Well, that's it from me, everyone. Thank you so much once again, everyone, for listening to this podcast and for following. I really appreciate the support and I really appreciate all of the interest. I am thinking about rolling out a newsletter, so if you haven't subscribed to the Law Lens mailer, then absolutely do, because I am going to be bottling up all of my posts, all of the information, all of those little tips and tricks that you might need here and there along your employment journey. Thank you so much for tuning in. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.